Uh-oh. Oh no. That's it. That's it for Johnny. The case is definitely gonna get thrown out over this one. Good job, Eve Barlow. Good job. Welcome back to the channel, everyone, and welcome if you're new. I'm Pluto, your favorite lawyer from the land down under. And can someone please tell me what you think about this photo? Because I think it is so painfully photoshopped. Look at Dr. Curry's head. Now, I could be wrong. I don't want to be mean. Maybe she just looks weird in the photo and it's authentic. I just really don't think it's real. Now, this was posted by Eve Barlow on Twitter and, obviously insinuating that Dr. Curry is biased and she's best friends with Camille Vasquez and it destroys the case and that it should be reviewed based on this alone. It's not gonna happen before anyone worries about this. Today, we will be looking at Amber's prospects. I did make a video earlier in July where I covered her post-trial motions. If you did watch that video, then you'll remember me saying that post-trial motions are more for errors of fact, whereas appeals are for errors of law. So the post-trial motions are not necessarily going to be reflected or replicated in the grounds of appeal. Now, I don't have access to her notice of appeal, and I'm fairly certain that her appeal brief hasn't even been filed yet. So it's going to be guesswork based on the 2+ years, I think it's way over 2 years now, almost 2.5 years of covering this case right from the beginning. Now, many of those grounds may also be reflected in Johnny's grounds of appeal, because when we looked at Johnny's objections to the final order in the last video, there were a few catch-all objections, which referenced all the demurs and all the motions in limine, all the motions for summary judgment, etc., that Johnny has filed since 2019. So the first one, which also applies to Johnny, is the declaratory judgment that Amber Heard should be rendered immune from any liability by virtue of the Virginia anti-SLAPP statute. The purpose of an anti-SLAPP statute is to prevent litigants from encroaching upon another party's freedom of speech and freedom of expression by wielding defamation law against them as a weapon to silence them. In Amber and Johnny's case, this would kick in solely with regards to statements made about matters of public concern. I think it is very much arguable that DV is a matter of public concern, and these statements would be protected by the First Amendment. Now, there is a very important proviso housed within this statute, which is actual malice. At this point, we all know what it is. So if actual malice is an element that is present, meaning the person made the statements with a reckless disregard for the truth or knowing that it's false, then this immunity just simply doesn't kick in. And this is why Amber Heard's motions for a declaratory judgment to basically have the court declare that she is immune by virtue of the anti-SLAPP statute. That's what a declaratory judgment is in this instance. The reason she failed is because of this additional proviso of actual malice. And so what the court has kept telling her time and time again, because she has filed numerous times to be declared immune, the question of actual malice is for the jury to decide. It's a question for the fact finder, essentially. And that's why the case needed to proceed to trial. Now, the same argument applies to Johnny, because Johnny, too, in response to the counterclaim in his defense, asserted that he should be protected by Virginia's anti-SLAPP statute, and he, too, failed. Another grounds of appeal is abuse of judicial discretion. And this relates to admitting evidence that shouldn't have been admitted, or vice versa, preventing evidence from being admitted when it should have. This is reflected in Johnny's objections, so I anticipate that this would be a grounds of appeal for him as well. Now, in Amber's case, the latter has been very heavily referenced by Amber Heard herself while she was on the stand. She told Camille, "I have plenty of evidence, plenty of photographs, journal entries, therapist notes that would prove everything I'm saying, but I didn't have any say in whether it was admitted into trial or not." So, for example, Amber's team really tried so hard to get Stephen's text with regards to the Boston flight and the apology he made. They failed, and they tried this multiple times, but it was hearsay. Stephen was not a witness. So this could definitely be used as a hint for a grounds of appeal. It is a question of law, not fact. We're looking at whether the court made the wrong decision or made an error of law in deciding whether certain evidence was admissible or even inadmissible. The fact that Stephen wasn't a witness is what prevented this text from coming in, because if he was sitting there, It could have come up and he could have been questioned on it. It could have been used to impeach him when he denied what happened on the plane. So I don't see how this is going to succeed, because it wasn't a matter of improperly suppressing it. It was a matter of not calling the witness at all. And let's not forget that if she had anything, because she claims that this evidence dates back to 2012, if not 2011, but definitely since 2012, we would have seen it by now. Back in 2016, she went to People magazine and she went to, well, The Sun, as we all know, which led to an entire libel case of its own, providing them with photographs from the 15th of December 2015 and the 21st of May 2016 incidents. Where were these photos that you said have been suppressed by the court? Why have we not seen a single photo in the past 6 years? This isn't the type of woman who would just sit on her evidence, because she definitely did not anticipate this happening. When she was making her allegations back in 2016 and going off and providing magazines with photos, doctored photos, by the way, they actually made them look a lot worse than they actually were. This woman never imagined that Johnny Depp would sue her. And so she had no reason to sit on this evidence. She would have given the world everything to destroy him, because that's all she ever set out to do. So I call bullshit. Let me know what you think in the comments. I'm gonna bring in juror number 15 real quick, because I never actually made a video covering the court's order. So we all know that that motion was denied, because it was actually juror number 15 who showed up to trial, who ended up filling the form. He's the one who got vetted. He got interviewed in a voir dire. Amber Heard's party had plenty of notice, plenty of time to raise an objection, and they never did anything. More importantly, even if it was technically the wrong juror, that in itself is not grounds for a mistrial or an appeal. Amber's team argued that it wasn't our responsibility to make sure that the right juror showed up. Well, again, the court disagreed, and this is actually reflected in the Virginia Code itself, which states that any error in the information shown on such copy of the jury panel shall not be grounds for a mistrial or assignable as error on appeal, and the parties in the case shall be responsible for verifying the accuracy of such information. Emphasis added. Judge Ascarate going, I am so sick and tired of you. Please go away. She specifically mentioned a party cannot wait until receiving an adverse verdict to object, for the first time on an issue known since the beginning of the trial. The issue has been waived. When the juror received the form, by the way, there wasn't a date of birth listed in that summons. When juror number 15 filled out the questionnaire, he put his date of birth in, not his father's. And so when he showed up, there wasn't a discrepancy as Amber's team would have liked us to believe. This really shows you how much they are reaching and how desperate they are. When this complaint was first filed in 2019, Amber objected to the venue. She said, I have no connection to Virginia. Johnny has no connection to Virginia. Therefore, it should be transferred to California. That was denied, of course, obviously, since the trial ended up happening in Virginia. Now, many people like to say that this is forum shopping, which is a thing, and yes, maybe it was. It's not necessarily illegal to shop for the best venue for your client. But it's not like Johnny had no business filing the case in Virginia at all. There is a connection to Virginia. The Washington Post, the publisher. Yes, they weren't the defendant, but the op-ed was published by the Washington Post. And so that's where the cause of action took place. Because what dictates the venue is where the cause of action took place or where the defendant resides or conducts their business. And so in this instance, as soon as the Washington Post published the op-ed, defamation occurred in Virginia. Another potential grounds of appeal that they're probably going to try, because like I said, with Amber's team, it's not even necessarily whether it's legitimately a grounds of appeal or not. They're just going to try whatever and see what sticks. That's how they do things. They could potentially challenge the judge's decision to allow cameras into the courtroom. They did try to challenge it early on, and they failed. Now, of course, this would be linked to prejudice. But here's the thing. Unless there is obvious evidence of prejudice or bias on the part of the jury, specifically because of their exposure to social media and the news, this is probably going to fail as well, because it's not the first time that a court in the United States allowed cameras in. The Jodi Arias trial was televised. The Casey Anthony trial was televised. We have many high-profile trials that were televised. It's not beyond the norm. You know, it's not something so far-fetched and so ridiculous as to call for a mistrial. There needs to be actual evidence of jury misconduct, namely evidence that they violated their oath. They broke their oath. They might argue this was a high-profile trial. They weren't your regular private citizens. They weren't Jodi Arias. They weren't Amanda Knox. They weren't Casey Anthony. They're Hollywood darlings. Just Johnny Depp, of course, you know. I don't think Amber Heard was ever a Hollywood darling, let's face it. But they might try to go for that angle. I just don't see it succeeding, though. I keep coming back to it has nothing to do with the facts of the case. The jury listened to the facts, reviewed the evidence, looked at their instructions, applied the law, you know, their definitions and everything that they were given, what is actual malice, what is defamation, what constitutes republication. That was all given to them. And that's how they arrived at their decision. This was confirmed by the juror who talked to GMA a couple of months ago now. While I can't verify whether that was actually a juror, I'm going to guess Good Morning America did their bit in verifying that it was, and that juror confirmed that all they did was review the evidence. Social media did not come into play at all. And to be fair, whatever the news was reporting was what was going on in the trial and what they were witnessing firsthand. And then social media was reacting to it. So yeah, whichever way you look at it, I just really don't see this as a viable grounds of appeal. Insufficient evidence is also a grounds of appeal. In Amber's post-trial motions, multiple times she argued that there was no evidence to support the amount of damages that Johnny was awarded and that they were excessive. There was no evidence to support defamation by innuendo. There's no evidence to support that Amber republished the online article on Twitter, etc., etc. Another grounds of appeal, which featured in Johnny's post-trial motions that we discussed last week: improper jury instructions. Now, I don't recall if Amber's team explicitly mentioned this in any of their objections while the jury instructions were being written, but just so you know, it is a grounds of appeal. And in Johnny's instance, it was specifically with regards to the jury being instructed to consider either the mens rea, the intention of Adam or Johnny. So basically treating them as interchangeable, which assumes agency rather than having agency being proven. All in all, for the prospects, I don't think her appeal will be successful. I think this is a classic case of a defendant or a party not being happy, naturally, with the verdict that was rendered because it was adverse to them. And I'm not playing sides here, by the way, because I did say that Johnny has good prospects, because he does. The $2 million verdict that was made against him in favor of Amber Heard was indeed unsupported by the facts and contrary to law. If you're wondering why, you can have a look at the video that I published last week. I'll leave it there. Thank you so much for tuning in. I hope you found this informative. Let me know what you think the prospects are, and I'll catch you in the next one. Bye-bye.